everyone. We are delighted that you are here with us tonight for our next Extension Horses webinar series that we've been putting on here during the COVID-19 pandemic. And while the topics are not specific to COVID-19, they are certainly timely topics for discussion right now, and have also been designed to be around topics that may be particularly compelling to people, and topics that maybe people have a little bit more time to dip in to, given that so many folks are working from home. So again, I'm really delighted that you can be with us tonight. My name's Dr. Corinne Bump, and I'm with Cornell University's Cornell Cooperative Extension, and I'm part of the Extension Horses team, and I'll be serving as the moderator tonight. We are expecting quite a good group that will join us tonight, and so I just kind of want to talk through logistics about how this evening's program will go, and then we will kick off right into that. First is I want to let you know that we will have a poll that will come up here and shortly that will appear on your screen. We're looking to get a little background information. You should see that it just popped up now. We want to ask you to take some time here as we do some introductions to fill that poll in so we can get a sense of who all is on the call with us tonight, and a little bit better sense of what kinds of things, experiences you have, maybe the kinds of things that you're looking for. So you may be wondering, who are these Extension Horses folks? And so we just want to give you a little bit of background about us and a little bit more about the kinds of things that we do. So we are a group of professionals from various land-grant universities. So all of the land-grant universities have an extension program, and we are horse-loving professionals in the extension world that have come together to work collegially across the states on topics relating to horses, both in terms of research and education and outreach. So we're just like you, we're horse lovers and always looking for ongoing learning. We are in the land grant mission, very dedicated to bringing you good science-based resources, information, and material that you can trust, and help you be more informed about the kinds of decisions that you're making about your horse, and in this case tonight, your horse operations. So this webinar is part of a series of offerings, all of which have been recorded. As long as technology cooperates, we record these. We've gotten already a number of questions in about the recording, and my colleagues that I'll introduce here in a moment that are on the call will be working on getting the recording up on the Extension Horses website within a couple days at the most of finishing this up. Extension Horses, if you have not been to that website, you can either just Google Extension Horses, or you can go to horses.extension.org. So that is our home base for our website. We also have a Facebook page, and we encourage you to follow that as well. In addition to tonight's webinar and the webinar series that we've been running, we also have a wide variety of free materials available, including a series of infographics that were put together specifically for the COVID-19 pandemic, information that we hope you find useful. That information is not state specific. It's designed for general information and insight. We also have a number of recorded webinars and podcasts that are available on Extension Horses, and a host, again, of extension research-based articles, good, timely educational information. And then lastly, we have a number of subject matter resources, including online courses. So I hope that gives you a little bit of idea about what Extension Horses are, and generally speaking, the group that is behind this particular information. So now I want to just let you know who else is on the program with me tonight besides myself and Julie Fershtman. We have some folks that are the technical group behind this program, and will also be helping wrangle questions at the end. So we have Julie Ivy, who is from the University of Tennessee, and again, all of us are extension colleagues at land-grant universities. So Julie Ivy from the University of Tennessee, Krishona Martinson from the University of Minnesota, Laura Beth Kenny from Penn State, Colleen Brady from Purdue University, and Taylor Fabus from Michigan State University. And then again, I'm Corinne Bump with Cornell Cooperative Extension, Cornell University. So really thankful to have colleagues on tonight, as well as Julie, to be able to offer this program to you. Okay, so let's dive into the program by doing a quick introduction of Julie. So we are very excited that Julie offered her time and talent to this program tonight. It's a very timely discussion on the importance of having well-developed equine boarding contracts. This is not a program specific to boarding contracts for COVID-19, but Julie will be addressing some just good areas that need to be in place for any kind of emergency scenario. And so we ask that you do not pose questions tonight that are specific to COVID-19, but rather frame those in terms of a more general background. We also remind you that in terms of that, there are any number of different state approaches to emergency scenarios, and so please be conscious that state-specific questions will likely not be able to be answered. So Julie's going to cover the key components of an effective boarding contract, and we of course will have time for questions. We have a Q&A bar at the bottom, and so you can put in your questions into the Q&A spot. And then we have folks that will moderate those questions and either answer them in the Q&A part, or we will pose them to Julie at the end. So Julie Fershtman is a shareholder with the law firm Foster, Swift, Collins & Smith in Michigan, and she is widely recognized as one of the nation's leading equine law practitioners. And again, we are so pleased that she has offered her time to us tonight. Julie's practice crosses all breeds and disciplines and serves stables, insurers, professionals, associations, businesses, show management, trainers, and clinicians across the U.S. She is also an author of quite a few publications, and a most recent publication on equine boarding contracts. And we'll make sure to put that information up in the chat bar, the Q&A bar as well, and also follow up with links to that afterwards. So with that, Julie, again, we thank you so much for being with us, and we're going to turn it over to you.
Good evening. Hello, everybody. Thank you very much for letting me be a part of this presentation. So I'd like to thank the moderators and the organizations that they work with. We've got a lot to cover, and I know that everybody listening in has ideas in mind and questions in mind, and maybe even problems that they've encountered. I'm going to go very quickly through the subject matter. Here's the good news. Since this is being recorded, and since you will find that the slides that I'm sharing cover in bullet point form just about everything I'm going to talk about, you can refresh by taking a look at the slides a little bit later, and I'm glad that it will be on the system. So let's move ahead. Hang on a second. Why is this not going? Hold on, you guys. Here we are. The topic today is fine-tuning your equine boarding contracts. Why do we need to fine-tune them? Well, details really do matter. Details can prevent disputes, or they can limit them considerably. Let me give you some examples and bring this to life. Emergencies. You're the boarding stable. You got a horse in your care that's colicking. Emergency surgery is required according to the attending vet, but you can't reach the owner for consent. Surgery will be extremely expensive. What do? If you have nothing in writing, you've got a lot of problems here. This is one example of an area where a fine-tuned contract can be of use to you, and frankly, of use to the owner, and of course to the horse. Barn health. You've got a new boarder that came in but didn't tell you, if you're the stable owner, that the horse hasn't been vaccinated or has a contagious illness. Maybe the horse has just been exposed to strangles. The stable didn't ask, and now the whole barn is infected with the problem. This is a health problem. A contract can actually address this. A lot of stables are getting into the problem, for better or worse, of late payments or no payments. The current pandemic that we're going through, unfortunately, has a lot of us very worried about our finances. But if boarders don't pay or they pay late, What are the rights of the stable? What are the rights of the boarder? The contract can address that. Liability is a huge issue. Boarders are on the property. They can get hurt at the stable. I've had cases where they've been hurt by simply walking the barn aisle and slipping and falling, having nothing to do with a horse. I've had other cases where boarders are kicked, bitten, knocked down, or in some way injured. How can the stable protect itself? What can the contract do to protect the stable? Is there a legally valid waiver or release of liability within that boarding contract related to the horse? Sometimes no. Does the stable have a standalone release? Oftentimes they don't. These are more fine points to consider. Equine Activity Liability Acts, sometimes referred to as Farm Animal Activity Liability Acts, can have a huge impact on what goes into the contract that the stable uses. We'll spend a minute or two on that one. And finally, services. You're the boarding stable, but the boarder wants extra services. Maybe they've got an off-track thoroughbred that's a really hard keeper and wants double feed. Maybe the boarder wants double bedding, individual pasture turnout when you really only have group pastures and maybe a paddock. What are you going to do about that? The boarder may not want to pay for those extra services, claiming that your agreement covers all of that. That's where a fine point in your contract, if you're the stable, can protect your finances by addressing what you're going to do if you're going to offer extra services. These are examples of the situations that call for a fine-tuned boarding contract. So let's get rolling. Let's start with typical elements of boarding contracts, and let's get started. After this, by the way, I'll be talking about optional elements of boarding contracts. And after that, I'll talk about some unique boarding contract issues. I'll spend just a moment for those of you who are curious about contracts and COVID-19 and how you can address it or consider doing that in your contract. And finally, I'll talk about how insurance impacts contracts. We'll move on to Q&A. As I warned you, we've got a lot to cover. So let me get started. Let's talk now about typical elements of boarding contracts. This is the stuff that we're going to cover in just a moment or two that you would expect in any contract. First, the services. What services is the boarding stable going to provide for the fee that the boarder is paying? Seems pretty simple. You might think a contract says, we will board your horse, but that's where the details come in. Does the board include feeding grain and hay twice a day? Does it include feeding grain twice a day and free choice hay, feeding grain and hay 3 times a day? Does it include individual pasture turnout, group pasture turnout, paddock turnout, no turnout? Does it include blanketing and unblanketing, putting bell boots on or splint boots? All of these things can be specified in the contract as to the services the stable will provide. Quick digression. I worked on a lawsuit in Illinois years ago where a horse, it was a dressage horse, was kicked in the pasture by another horse and had to be put down. The boarder sued the stable, and the argument that the boarder raised is that the horse was supposed to have an individual pasture, not a group pasture, which caused the problem. The problem, unfortunately, came down to the contract. The contract said nothing about an individual pasture. What I always suggest is, if you're a boarding stable and you offer individual and group, specify it in the contract. What is the boarder paying for? It might cost more for an individual paddock or pasture. If you're the boarder, same thing. You want that contract, if you want an individual pasture, to specify you're getting an individual paddock or pasture. You're not going to be put in a group. Well, the Illinois case ended up resolving, but you understand the problem. Make sure your contracts avoid the issue, and that can save a lot of trouble. The second thing is law. What state's law applies? It may seem like a no-brainer, but typically it would be the law of the state where the boarding stable is located. Location for legal disputes arising out of the contract. I've got clients who are located very close to big urban areas. In a court of law, if a lawsuit arises, sometimes those urban areas aren't very understanding in the courts about horses and agricultural interests. But you want to make sure, if you have an option to use a jurisdiction that is friendlier to businesses in the horse or agricultural industries, you're going to jump at it. So the location for legal disputes arising out of the contract is something that lawyers like me like to use to protect my clients and their clients who are stables. If you are located in an urban, or that is to say a rural area, not urban, specify any legal disputes arising out of this agreement shall be brought in a court located in, and put your county in. Keep people away from the big urban counties where you may not get the friendly audience. The next is attorney fees. Who is going to pay the other's fees in a dispute? Sure, I'm a lawyer, and of course I'm raising that. But if you're a business, boarding stables who are listening in, why not put that clause in? Because if you word the clause in such a way that you might be able to recover your fees from the other side, there is a huge disincentive for the other party, your boarder, to raise a problem with you. Why? Because this clause in the contract says they may be paying your attorney fees. That makes a big difference. Attorney fee clauses, as your lawyers will tell you, can vary considerably. Some say if there's a legal dispute, the loser pays the winner. Other contracts are a little different. Put it in your contract. It can save you some money. The next is a clause I call a savings clause. We're not talking about saving money here. It's a clause that would say, if any part of the contract is invalid or unenforceable under the prevailing law, the rest of the contract lives on and is fully enforceable. That's important, especially for releases and waivers of liability. I think it's important too for a boarding contract. Lawyers like those in the documents. Next is resolving disputes. Nowadays, not everybody wants to go to court if they have a dispute. A lot of times people on both sides of the dispute want to mediate it. That is to say, get a trained mediator to get you to work out your differences, or arbitrate it, where you're not in a court of law, you're in a private forum. Sometimes there's one person listening to the dispute, a trained arbitrator, sometimes three, but that arbitrator takes the place of the judge. If you don't put those options in your contract, you may not be able to pursue them later on. Let's face it, when the parties are embroiled in a legal dispute, getting them to agree on anything, much less arbitration or mediation, can be really, really tough. Put that in as an option. You can also put it in that it is an option that the stable will decide if a dispute arises. The stable will decide whether a dispute will go to arbitration, and the boarder has agreed in advance that the stable's decision rules. The next is term. What I mean by that is, how long will this contract go on for? Typically in the horse industry, which I've been serving for, at this point, over 30 years, the term can vary, but I normally see month to month. That is to say that the contract has a term that goes on for 1 month, the beginning of the month to the end of the month, but it will automatically renew unless either party terminates it, as the contract says. Yes, I've heard of some contracts in the boarding world that go on for a year. I find that personally disagreeable. Yes, year-to-year contracts may be great if you are a boarding stable, but let's face it, there may be horses or boarders that you don't want long-term. The relationship can sour. Terminating can be difficult sometimes, but the typical term of a boarding contract, in my experience, is month to month with an automatic renewal, unless either party terminates. Let's go down to termination. Again, we're talking about typical routine elements of a contract. How much advance notice does the boarder need to give if they want out? How much advance notice does the stable need to give? I do say, you'll see it on the PowerPoint, exceptions for unique situations. I always recommend, for the stable's benefit, that if the horse that's kept at the stable is showing dangerous propensities, charging at the workers when they're trying to get it out of the pasture, turning its rump and threatening to kick people who approach its stall, reaching out and trying to bite people if the stall has an open door in front, the boarding stable may want those horses out for safety's sake if it doesn't have the ability to house a horse and protect people from a horse like that. So the stable may want an opportunity to get that horse removed sooner than a 30-day advance notice. I tend to put in my contract that in extreme circumstances, such as dangerous propensities of the horse or the owner, the stable may have the right to require that the boarder leave within 7 days. Boarders don't like that. Good luck getting a stable within 7 days. That can be very difficult. Stables do like that, because keeping a horse that may be dangerous it's a hazard to the stable. They don't want that risk. There was a stable that I represented years ago that had a boarder who unfortunately had a drinking problem and showed up at the stable drunk repeatedly. The stable wanted that person out because that person was a threat to herself. So the stable had the ability to invoke this unique clause to say you have 7 days to leave. These are things to consider, but make sure the contract says when the notice is given to terminate. Let's go into the final element, then we will move on to optional elements. Changes. How can the boarding contract be amended? What I often have suggested for stables is to have a clause that says that amendments to the stable must be done in writing and signed by the stable and the owner. That's important because sometimes there are amendments that are really important, such as the release of liability. Say the stable has changed its corporate name and wants to amend the contract to reflect the new name. Well, you'd want that in writing, and you want the release amended accordingly. So some of the changes are really critical. Other changes could be simply, we're upping the cost of our board by $5 a month effective next month. Those types of amendments, if you want, can be reflected in the contract that don't require a written agreement. But for the protection of all parties, it certainly is a good idea for amendments to be in writing. Oh, and for anybody listening in wondering, oh crap, do I have to print out another 6 pages of my boarding contract with an amendment? No, you don't. All you need is simply a page that says amendment to boarding contract, and write down what section of the contract is being amended, have a signature line for the boarder, signature line for the stable, and there you go. If you want amendments to be acknowledged in writing on the internet by an e-signature, that's an option. I can't speak to the legalities of it, but either way, you want proof that the other side has agreed to it. Let's move on to optional elements of boarding contracts. These are the things that can make a difference. People have very strong opinions about all of these elements that we're going to talk about right now. Let's run through it. I already hinted about the first one, extra services. You're the boarding stable, and the boarder with the off-track thoroughbred who's a hard keeper wants extra feed, maybe free choice hay. That may drive the other horses crazy if one in the barn has free choice hay and the others are starving and they're banging on their doors. But the point is this: if you're the boarding stable and you do have a request for some unique extra service, should you simply write it off as the cost of doing business? Give this horse a significant amount more feed, bedding, whatever. Maybe not. Of recouping your investment in all of these things that you're doing. Sometimes stables can offer a schedule of charges for extra things. Boarders hate this, stables love this, but it's worth considering. Here are some examples. The schedule of charges for extra services, which would be an appended part of a boarding contract, can say, if you want double grain, it's going to cost blank. If you want double bedding, it will cost blank. If you want individual paddock or pasture, blank. If you would like us to hold your horse for the vet or farrier, it is this. If you would like us to administer any medications, it will be blank. The stable can put that in writing. It helps the boarder in a way to know what the charges might be. It also helps the boarder, if they don't want to pay the stable to hold the horse for the vet or farrier, to team up, buddy up, if you will, with another boarder. One can hold the horse for themselves and for their friends. People can work it out, but you've made it very clear in the beginning. These are my charges, and you will have referenced it in your board contract, that this is what the monthly board fee is, but attached as Exhibit A is my list of charges, and I will have the right, I the stable that is, to amend this with 30 days notice to the boarder. Consider that as an optional element. Let's go to the next one, damage to stable facility by horse or owner. Who pays? This is a big issue because some horses are holy terrors, as you know. They're going to kick through the stall. They're going to, if they're cribbers or biters or chewers, they're going to bite down the stall. Maybe they're tied up to a rail and they break it, or to a post and they break the post. Who pays for the damage? Up to you. Some stables say, oh, well, it's the cost of doing business. I'm not going to have the boarder pay. Others say, I will charge you everything. That would be materials and labor. Other stables say, I will charge you the materials and labor charge beyond the first $150. You get the idea here. Worth putting in the contract. Next is equine health. I gave the example of the horse that came into the barn and the boarder didn't tell the stable that this horse had been exposed to strangles, and the prospective boarder knew it. Here's where the boarding stable can protect every horse in the barn. Request details about the horse that is coming in. Of course, you'll need a Coggins test. Some stables want a health certificate. It may be required anyway, but then you can kick it up a notch. Ask for evidence of vaccinations, deworming, a representation from the boarder that the horse has no illnesses or diseases or anything like that. Some of my clients who are stables want proof. They'll say, show me your past veterinary bills. I want to take a look. Or they'll say in their contract, at stable's request, owner will provide it. The next on this point of equine health is, for the benefit of the horses, optional ongoing health programs for all boarded horses. Once that horse is in the barn, you want to make sure that the horse is being vaccinated just like all the others, dewormed just like all the others. Most of my clients, in fact 99%, have an ongoing health program. How they implement it is up to them. But often what they'll do is say, this is the schedule recommended by our attending vet. These are the vaccinations. You arrange it using your vet or our vet, show us proof, and you're good to go. Other stables, typically trainers, will say, you're in our program, we will arrange for the vet to do all of these different things. These are options, but protecting the ongoing health of the horse is critical. Next in the list is money. Stables would benefit, in my opinion, by imposing late payment fees, a certain amount per month when board isn't paid, not a percentage, but a dollar amount. Interest on unpaid balances. Just about every boarding contract I've seen has an illegally high interest rate. Please remember, interest varies on a state-by-state basis, but a stable would be wise to say that you will collect blank percent, which would be the highest rate you know of under your state law that you can charge, or the highest rate allowed under the law, whichever is higher. Security deposits, I put that down here. I'm personally not a fan of it. Some stables charge it. If you do, certainly put it in writing and be clear for the boarder's benefit when they get it back. Next is resolving disputes. We talked about mediation and arbitration previously. Let's move on. Waiver and release. I think that what separates a good contract from a great one is a release of liability in the boarding contract to protect the stable. And that would be a clause that varies with state law. Most states will allow a release to be enforced. But what language goes into it? Well, that varies depending on where you are. Very important to consider. I do recommend, if you are a boarding stable and the boarder has signed a release of liability pertaining to the horse, that you have a separate release for everybody of legal age who is entering your facility to sign. So you've got an extra set of paperwork, but this is how you protect yourself if you are a stable. You have your boarding contract with a release relating to the horse, and you have that standalone release on file from everybody else who's on the property. Indemnification is a very complex subject. That's a clause in your contract that says if the boarder causes an injury and you, the stable, are sued because of what the boarder has done, the boarder agrees to indemnify you, protect you, hold you harmless, pay your legal fees. Sounds really good, but it is very complicated. And sometimes the boarder's insurance will not be there to provide that protection if the stable gets sued for something that it didn't even cause. It is an important clause to consider for your contract, and I always believe in including it. 2 more points and let's move on. Restrictions preventing the boarder from assigning the contract. Jane Doe has great credit. She's got a great personality. You want her in your barn. But what if she says, well, I've lost my interest in horses, so I am assigning the contract to my cousin John. John is impossible. You don't want him in the barn, and besides, he's got a bad reputation for pain. Don't allow boarders to assign the contract to anybody else to be the boarder unless you've agreed to it in writing. There's a next and the final bullet point in here about whether the boarding contract should specify the value of the boarded horse. I do not recommend that. I think that there are a lot of problems associated with it, but there are a lot of stables that have the contract say, we agree, here's the value of the horse. I think it's more trouble than it's worth. Let's move on. Unique contract elements. These are things that can vary. One is the State Farm Animal or Equine Activity Liability Act. These laws have language that equine activity sponsors and equine professionals need to include in contracts. Sure, some state laws don't have this requirement, such as Connecticut and some other states as well. But the point is that many of these statutes will affect what goes into your contract. If you are a boarding stable, you will qualify as an equine professional, and chances are very good that you need to take a look at your state equine liability law and see if it has that language. Put it in your boarding contract, put it in your release. We may have some trainers here. Put it in your training contract. Basically, my recommendation is put it in all your contracts, whatever that language is that your state law requires. And of course, it varies all over the country. Health emergencies, we talked about that at the beginning. How will they be handled? Well, let's go back to the example. A horse is colicking and you can't find the owner. Here's a great opportunity now for your boarding contract to deal with the emergency and to talk about what the stable is going to do. You want the boarder to give you full authorization to do whatever is needed to protect your horse. And you, the stable, will decide what makes sense. The boarder has been out of work for several years, has been paying you while still looking for a job. Chances are, if the surgery is going to cost $5,000, $6,000, $7,000, you may not be willing to do that. If you can't find the owner, you may just say, well, veterinarian, put it down. But a complete authorization, I think, benefits the boarding stable. Now, boarders, this happened to me once. I took a vacation with my husband years ago, and I had a horse with a pretty serious problem. Consider putting it in writing if there are limitations, but don't put the boarding stable in a tough position. Here's what I mean by that. Some contracts will say, if the owner can't be reached, the stable will authorize on the boarder's behalf up to $2,000 in veterinary bills. Well, what if the veterinarian, when the owner can't be reached, says, well, we need to do X procedure and it's going to cost $2,500. And the boarding stable says, well, I'm sorry, that exceeds the authorization I've got. You're going to have to euthanize this horse. And of course, the vet does that. But then the boarder has terrible feelings for the stable. Sure, the stable acted as the contract required, but the boarder may come back once they are reachable and say, wait a minute, you put my horse down for $500? Well, yes, the contract allowed for that. Very difficult positions for the stables and the owners. The best recommendation I pass on is for the stable to have the owner have a credit card on file with the attending veterinarian and work it out with the veterinarian as to any limits on expense if there is an emergency. But I do like broad authorizations for the stable. Stableman's lien laws, adjuster's lien laws. What if the boarder doesn't pay? Are you going to follow that state law? Some state laws are terrible. Here's what I mean by that. Just about every state in the country has a law on the books. Many of these laws, like Michigan, were passed in the 1800s. They don't help in a lot of respects. Sometimes you have to go to court if you have a non-paying boarder and you want to sell the horse. Sometimes you have to have a lien sale and you have to hire somebody to run it. And the statute gives you all kinds of details to go through. Can you circumvent that and do things differently? Very possible. Remember, though, that you have one of these laws. It may be beneficial to mention if you're following it or if you decide that you're not going to follow it. Going back to resolving disputes, mediation, arbitration, we've talked about that before. You want your contract to mention if the parties have agreed to it. The final bullet point, and let's move on, is what if you are the boarding stable and the boarders all have riding instructors who they want to bring in to give lessons. But you're the boarding stable and you realize I'm not insured for lessons. You may, as the boarding stable, want to put restrictions on outside trainers. Some stables say, we don't want you, period, because you may not have insurance. We may be exposed to liability from what you're doing with these lessons that you're conducting. Other stables say, we'll work with it. We want our boarders happy, and we know that lessons can be very important. Outside trainers can be. They'll have a list of restrictions, and they'll want a separate contract with those outside trainers and instructors. Often, at the very least, the boarding stable wants proof that the outside instructor or trainer has liability insurance, maybe even adding the boarding stable as an additional insured. But the stable can at least negotiate that and have restrictions and put it in the contract, whether they're allowed, if they're an outside trainer or instructor, or whether they're not. Let's move on. Let's talk about COVID. I know a lot of you were curious about it. As you're aware, we're not going to cover it in any detail. The point I want to make before getting very briefly into this one slide is I have yet to see in 33 plus years of practicing law, I have yet to see a boarding contract that has a clause that says in the event of a major emergency that involves plagues or pandemics, each party is excused from strict compliance with this contract. It doesn't exist. And I will tell you that many major corporations all over the world don't have contracts that allow parties to be excused from strict compliance with the contract if a problem occurs from a plague or pandemic. This hasn't occurred in the world of contracting to most people. Somewhere out there, there's bound to be a contract that does. So let's talk about COVID-19. What am I talking about here? A clause that lawyers love to talk about these days is a clause called a force majeure clause. If you use this in your regular discussions, people will think you're really smart. But the point is, it's a clause that says that one or both of the parties' performance under the contract, living up to the terms, is excused if there is a serious unforeseen event beyond your reasonable control. Tornadoes, earthquakes, things like that. These are force majeure clauses, and the big fancy contracts often have them, not boarding contracts. But if you are considering protecting yourself in the future, if you're a boarding stable, and so you want the boarders to know that you may want to be a little bit lax in some of your very technical requirements, maybe on the volume of times you're going to pasture or something else, consider talking with your lawyer about having a force majeure clause, but put it on steroids and make sure it says in the event of plague or pandemic, you may not be required to follow the strict terms of your contracts. So the takeaway on the COVID-19 and boarding contracts is this is extremely complicated legal contracting stuff. This is beyond the scope of a typical boarding contract. You would be strongly encouraged to discuss it with your lawyer. Finally, we're getting to the issue of insurance. I think insurance is an important element to consider for boarding contracts. Let me run through it quickly. First, equine mortality, major medical insurance on the boarded horse. The boarder buys that. I haven't seen a boarding contract that obligates boarders to buy it. And frankly, I don't like a contract that does, because some horses are uninsurable by virtue of age, pre-existing problems, a number of different things. But it is important, in my opinion, for the boarding stable to know if a boarded horse has insurance. And I think it's a great service that the stable can provide for the boarder. And I think boarders would love this clause. And the clause would be this: a clause that says that the boarded horse has equine mortality, major medical insurance if you want, with this insurance company. This is the 1-800 emergency phone number to call. And here's why it's a great benefit to the boarder. Boarders, if you're unreachable, they want the stable to call your insurer and give them the immediate notice that you're required to do under the terms of your contract. What do I mean by that? I mean that the typical boarding contract has the typical mortality policy has a clause that says that if the insured horse has an injury, illness, disease, lameness, or problem, you, the owner, or someone on your behalf are required to give the insurance company immediate notice of the problem. How the insurance company reacts isn't the point, but the point is that there are insurance companies that will deny coverage if they feel that that clause has been violated. And I can tell you, I have litigated these cases before, frankly, on behalf of companies. I don't want anybody on this call to encounter a problem where you haven't complied with your policy on the issue of notice. So your boarding contract can put in it that the boarder gives you the 800 number to call. You can make that call and get the ball rolling with the insurance company. This could save not just the life of a horse in the end, this could save a lot of money for the boarder. Very, very important. Let's move on to stable liability insurance. No, it's not a contract provision, but stables who are listening in, if you're a boarding stable, I hope you know that you would be wise to purchase commercial general liability insurance. If horses are only a side business, you can look into an incidental business endorsement, but there is business insurance you would need to have, because you're not just doing this for yourself. If you are a boarding stable, that suggests to me that you're taking on somebody else's horses for money. And that means that your homeowner's insurance won't be there for you if you have a claim. You have a business pursuit. Certainly look into commercial general liability insurance, look into care, custody, and control endorsement. That is coverage in case somebody accuses you of giving negligent care to a boarded horse. Let's move on. I'm going to pass on the personal horse owner's liability insurance. Well, let me go back. Looks like we have just a minute. I see that my moderators are hoping I can stop talking and start moving ahead. Let's take a moment on personal horse owner's liability insurance. If you are the boarder and you boarded your horse with a stable, and you are somewhere else off premises, that's why you're boarding. What if your horse kicks, bites, knocks down, or injures somebody? What if somehow your horse jumps the fence, runs into the road, smashes into a car, and causes an injury? You are at risk of a claim or suit against you. Whether the claim or suit has merit, that's not the point. The point is it benefits you to consider purchasing liability insurance that applies to your horse wherever it goes. Stables, you can encourage your boarders to have it. Some stables require that horse owners purchase personal horse owner's liability insurance. What do I think? I think it's a choice of the owner, but I think it's a wise choice to have that insurance in place. Well, I think we're at the question and answer part right now. So Back to you, moderators.
Thank you, Julie. Boy, my head is spinning. What an amazing amount of information. You covered so much and so many good things there. Just really appreciate your depth of information and knowledge. So we do have some questions that are currently in the queue. As we go through those, if others have questions, please put them in the Q&A, and we will either get to those or we'll combine themes and talk about that. So the first one, Julie, is a question from someone that says, the place I board at continues, I think this has to do with late fees for boarding. So the place I board continues to go rounds with one of their boarders being late on their payments. It's in our contract that they will owe a late fee, but the owner operator seems to ignore that. I guess he said a few times that their barn contract is not legal and they cannot do anything. Wondering what should they say to this owner operator to get him to abide by their contract. And I think a follow-up to that is that if you have in the contract that a late fee will be required and that is not instituted in one instance, does that make it void in other instances?
Good questions. I'll try to be brief because I imagine you have several. Whether or not a late fee is legally valid and enforceable will depend on the law of the state. A quick example, I've mentioned in my presentation about interest on unpaid balances. And I'm a believer in clauses like that in a board contract. But some stables will say, in addition to the interest on unpaid balances, the late fee is an additional 10% of the balance. So now you have an interest rate on the unpaid balance and an extra percentage. Sometimes judges don't like that. Judges will view that as all combined as some form of an interest. And when you add the two together, you get into what is known as usury, which is an illegally high rate of interest. That would be an example of a late fee that is on very shaky ground and not enforceable. But the way I view it in general is if the stable imposes a reasonable late payment fee, it should be enforceable because it's agreed upon between the parties. They had an opportunity, I would think, to discuss it and negotiate it, and the stable should stand by it. The way I view it, I'm going back a little bit in time, but before we had the ability of a stable to take credit cards, to operate with Venmo and all these different payment options, when the boarder came in with cash or check, that stable owner would have to jump in the car and deposit it in the bank. And that required an extra trip, and it was an inconvenience. So that late payment fee was designed to protect the stable from that inconvenience factor. Nowadays, it's a little bit different. But in general, I can't imagine, unless there's a state law standing in the way, that a late payment fee would be unenforceable. Let's get to the question of what if the stable has a late payment fee called for in its contract, but repeatedly just ignores it. And now you have a boarder in the future where the stable is imposing it. And the boarder is saying, wait a minute here, these people got a break on the same situation. What about me? Well, first off, it looks to me like the stable would be showing that its contract has no integrity if it doesn't enforce it. On the flip side, the stable should be able to assess the situation. Late payment fee perhaps was set aside and ignored by the stable because the boarder was out of a job. The boarder had a hard time with some personal matter. Major debts hit the boarder, and the stable wanted to excuse the fee. There is an opportunity on part of the stable to have some discretion, but can the fact that the stable has given one person a break mean that the stable is not able to enforce that late payment fee in the future? Very hard to say. I wouldn't take that to the bank if I were the non-paying boarder. Let's assume the stable has discretion, and frankly, I think that's an issue that would have to be evaluated on a case-by-case basis. Next question.
Great. Thank you so much for that. So that I'll do the next question, and then I think Colleen is going to jump in with the one after that. So I have a question about, would you expand on the relationship with the waiver of liability and best practices? As an instructor in another discipline, in this case, this person is involved with ocean kayaking. That sounds exciting. We always had a release signed. We could insist on a PFD being worn as that way, a personal flotation device being worn as that was considered best practices. As a follow-up, liability lawyers tend to go where the money is. Who is liable in an accident in the barn? Can a boarder? No. And so it seems like there's a couple questions there. So I think the first is about releases and the waiver of liability. Yep.
Okay, you're right. There is a lot to cover on that. And the first question alone is a pretty loaded one. So I'll try to be succinct if I can. I'm going to take the standpoint now of the stable. There are boarders listening in on this who are not going to like what I have to say. I am a strong believer in waivers and releases of liability. I am a nerd with respect to following the law of waivers and releases of liability, including in kayaking and whitewater rafting situations. It's a fascinating contract because on one hand, it is protective of the stable. It's a person agreeing that they're not going to sue you for certain things. On the other hand, it is a powerful contract. You have effectively, if the document works, taken away someone's right to go to trial against you and collect potentially millions of dollars. That piece of paper is worth a lot. And I believe in it if it's properly worded and properly signed. So the relationship between the waivers and the boarding contract I'll get to first. Just to reaffirm, if you're a boarding stable, it would be my recommendation that you have a boarding contract that is signed by the boarder. So I have a boarding contract with you to take care of my horse. My husband, who doesn't like horses, isn't a party to the contract. He is not contracting with you. He won't come to the stable very often. But when he does, we get to your next contract, which is your release of liability. You'll ask me as the boarder to sign your release in case I am injured on the premises and I am accusing you of negligence leading to my injury. You want me to sign a release, but you also want my husband to sign a release. He didn't sign your boarding contract. You don't have a release from him until you present him with that document. And then I have a daughter. She's an adult now. She will be turning, she's in her 20s right now. She's going to be turning 22 this year. When she comes to the property, you're going to present her with a release and you're going to have it on file. This is an important document, and if it's properly worded and signed and you've covered all the requirements under your applicable state law, you've got something that's very powerful. Will it protect you against everything? No, not necessarily. I've written a book, Equine Law and Horse Sense, that talks about what they do and what they don't do. Let's talk for just a moment on best practices. I can't say as a lawyer what I am recommending all stables to do and all instructors to do, but I will say that there are optional things to consider in a release and a service contract. And when we talk about equipment, I'm a big believer in a clause in a release that tells people that either they must wear a helmet, like in New York with a helmet law, or that the stable or instructor or trainer is warning the signer that they should purchase and wear properly fitted and secured ASTM standard SEI certified F1163 protective equestrian headgear. Put that in writing and have an extra document in addition where they have signed off that they know about the benefits of a helmet and they are choosing not to wear one, or that they are not asking you to provide one, and they're not asking you to check whatever they wear. Be a believer in that. And that carries over to other protective gear. If it isn't required by law for the person you're doing business with, then you can consider putting in your contract that you have made them aware that they may need to wear it. I have some clients in the eventing world. They put in their contracts reference to the protective vests if it's only for training and they don't feel it's required. So sure, mention it within your contracts and keep it as part of the elements within it. I could get to the question about who is liable unless you'd like me to move on. I can literally do one sentence.
Yeah,
actually, we have a couple other liability related questions that I wonder if we can I know liability is a huge issue.
Why don't we take those? Because the other question is who is liable, but we don't even know the circumstances and we really can't answer.
And these are both pretty specific. One is about barn owner liability if one of the boarders or lesson people brought COVID into the barn and others got sick, whether it was disclosed or not. And the other liability question is related to liability for minors riding. In a divorce situation and the parent has custody of the minor, does the board, I think this is from the boarder, the stable owner, do they need the other parent's signature or only the signature of the parent with legal custody?
Let's start with the release question and minors. First, the backdrop of the whole thing is the question of whether a minor could be governed by a release of liability. Around the country, courts are grappling with that question right now. And more specifically, the question is, can a parent or legally appointed guardian, and we're not talking about Aunt Sue, we're talking about somebody who has been ordered to be the guardian by a court of law, can they sign a release of liability that signs off on the children's right to sue? Around the country, the courts are not in agreement. The majority of courts around the country are now saying, no, you can have a parent say that they're signing off for the kid, but when push comes to shove, a legal dispute is filed, that document will be unenforceable in most states that have addressed the issue. That's not to say most states in the country. That's just to say most states that have addressed the issue. Courts just can't agree. But let's get to the question in this sense. What if you have a release and the state is willing to enforce it, and you've got divorced parents, which is a lot of parents in the horse industry. The father is totally supportive of the horse activity. The mother isn't. The father signed the release on behalf of himself and his minor child. The mother says, hell no, I'm not signing. What do you do? Well, as a matter of law, when I have looked at the issue as a general matter, it's enough to have one parent signing the release if the state is willing to enforce it as to the kid. But in the best of all worlds, it is great if you can have both parents sign it. Why? Well, it may be that the mother one day may be picking up the kid from a lesson, wandering around the barn and gets bitten, kicked, injured, whatever. I think it would help to have that mother's signature on a release, because if you don't, that mother might have recourse against the stable that the release might prevent. So strongly recommended to have both, typically enough to have one, but you know my caution in regard to that. There was a question posed about a boarder who is COVID positive, knows that she is COVID positive, comes to the barn and puts everybody at risk. But the question was, is the barn owner liable here? Well, let's get to the backdrop of this. For all we know, anybody who contracts COVID, even if somebody who was positive was at the barn, could have contracted it at the grocery store, just about anywhere. Anywhere you go, if you are in an area where somebody who was COVID positive has coughed on you, didn't have a mask on, touched a doorknob, you're at risk. So even just merely proving that a person who contracted COVID got it at the stable is a bit of a stretch, because we really don't know. But the question more specifically, or more generally, I guess, is should the barn owner have implemented some precautions to make sure that people at the stable are protected? Because there could be a COVID positive visitor. Yes. Could the stable have said no COVID positive people allowed on the premises? Absolutely. Would that be in a board contract? Probably not, because I don't think anybody predicted this from happening. Here's the safest bet. Follow the law of your state, follow the governing directives. In my state, we have a shelter at home restriction. Frankly, as I interpret it, that would say boarders really shouldn't be visiting their boarding stables. Boarders are livid about these interpretations. They want to see their horse, but a very technical interpretation would say the stable has got this, it will live up to its contract, and boarders should not be visiting the stable. So I would defer to what the state requires with regard to COVID and with regard to doing business, and follow it to the letter. And frankly, it may not be popular, but I would err on the side of protecting the health of your boarders. And because it's so difficult to make sure that you don't spread it when you're asymptomatic. What's the next question?
So we have one more on minors, and then I think we'll turn it over to somebody else to ask. We're kind of trying to put them in groups here as we're moderating. Could a boarding facility be responsible for the injury of a child that is left unattended? Let's say mom and dad dropped off their 14-year-old at the facility while they go out on a Saturday, and a release was signed. And just to add something, I used to be at a barn where they said there was a barn rule that said unattended children will be given caffeine or coffee and a puppy. So I don't know if that could really have stuck or not.
Well, I owe the fact that I'm here today to having been left to fend for myself at a boarding stable from age 11 on up. Nobody watched me. I did what I wanted to do. And frankly, none of my clients would allow that. It was that open-ended opportunity to interact with my pony that I think gave me everything I am, made me everything I am today. But let's get to the question. If an unattended child is injured at the stable, would the stable be liable? And I hope whoever asked that isn't dealing with a current lawsuit, just looking for my take on it. Certainly the answer that lawyers would give is, gee, it depends. But let me hone in a bit on that. Has the stable undertaken an obligation to monitor this child? Riding instructors, if you have, for example, a lot of minors as your students, have you told your parents, the parents of the children that is, these are the hours to come and get them, drop them off here and pick them up at whatever period of time? Have you given the parents an understanding that these children are going to be supervised while the parents aren't there? If you have undertaken a duty to monitor the children and somehow you fall short of it, you have set yourself up for a problem. So what do you do about that? Well, sure, there are waivers and releases of liability, but that may be tough because most states around the country who have looked at the issue don't like waivers with minors. There are other options if you really want to be risk averse, and that is to have a system where you, the riding instructor, have an assistant who can watch the kids. Or you can have a tack room with a table and things for people to do, so the kids are not wandering around the barn where they may do something that might get somebody hurt. There are different alternatives to it. But what really matters is, what understanding does the trainer instructor have with the parents and the children, and how that trainer or instructor can extricate itself from an obligation to keep watching the children. What I have said in my boarding contracts is, I would have it say that as a rule, I always attach stable rules to my contracts. The rules would be, all children under the age of 13 must be supervised by an adult at all times. Stable is not responsible for monitoring your children. You must find a responsible adult to watch your children. Okay, so if you have a boarder who has a 13-year-old and the boarder also has a relative who is an adult, if the two of them come to the stable together, you've got your monitoring, you've got your protection. So there may be ways around it, but for stables, find a way to make rules and to adhere to them. And the same thing with instructors and trainers. You may not be the boarding stable, but make it clear, preferably in writing, as to who is going to watch the children when your lessons are done.
Great, thank you, Julie. This is Corinne, and that was a perfect lead-in because we have a series of questions about barn rules and how that pulls into contracts. And just a quick reminder that we do still have a poll up, and so if you could please, if you haven't responded to that, if you could please do that. So are there limitations, Julie, on the kinds of things that can go into barn rules? And then an associated question is, should barn rules be part of the contract so they're all signed, or barn rules separate and then require a signature on the rules?
These are really good questions, and I probably ought to have included that in my general discussion, but now that we're on it, let's go with it. I believe a good standard provision in a boarding contract is a section on stable rules where it doesn't list the rules within the contract, because the rules are ever changing. You see something stupid in the barn and you may want to create a rule for that, but the last thing you want is to have to amend your contract. But I would recommend a couple of things. One is a clause in the contract that the stable is attaching a copy of its most current rules, and the stable will post its rules in the barn, certain places, probably tack rooms, cross tie areas. But even further, the next is the stable retains the right to amend its rules with 30 days notice, and will give the boarders copies of all amended rules, and that the boarder agrees to follow them. I don't think that the amended rules, when implemented by the stable, need to be signed off on, although it certainly doesn't hurt. The best thing that the stable can do is, I suppose, get something in writing where the boarder has either put pen to paper and said, I have received this, or has sent an email or a text back to the stable. I have received your amended rules. You could do that. Otherwise, your contract can say that all you need do is send them your new rules and advise that these will take effect in 30 days. The first question was, are there limits on what goes into rules? And as I view it, stables are usually on private property. We'll put aside stables that might be operating as concessions on federal lands, state, public lands. We're going to talk about people operating on their own property. As far as I'm concerned, reasonable rules make sense. You can do what you want. It's your property. So are there limits? If people who are your boarders don't like your rules and you have shown those rules to them before they come in, let them go to a stable down the road. If a boarder doesn't like your proposed new rules and thinks they're unreasonable, but they don't take effect for 30 days, the boarder can give you 30 days notice, if your contract allows, to get out of there. So what kind of things have I seen in rules? Rules can be anything from hours of operation, except in emergencies, a colicking course, you've got to walk it. The vet or farrier have out hours. You want to have somebody there to hold the horse. But hours of operation, no smoking in the barns, visitors must sign the stable's waiver or release of liability, or visitors must be approved in advance by the stable. Roving riding instructors and trainers who are not regular staff of the stable must be approved in advance by the stable and have a contract in writing with the stable owner. These are some of the rules. Other rules can be a little bit more restrictive in terms of where you're allowed to ride, hours of use of the indoor arena. If it's a lesson stable, maybe the boarders have it in the rules that they're only allowed to use the arenas during certain hours. Same with the outdoor arenas, things of that type. As I view it, it's great to put these in writing so everybody knows what the plan is. And they can also, stables have the flexibility to change them as problems occur over time. Boarders too have the ability, if you can communicate with the stable, to affect the rules, maybe add some new ones, maybe take some out. But I'm a big believer in them, and I'm a big believer in communicating them and posting them and sending them off to the boarders.
Great, thank you, Julie. So why don't we see if we can get through in 5 or 6 minutes a couple of these last questions. So we have a couple questions that have to do with people who, for termination clause. So some people will just leave when they want to leave, according to some questions here. Is there any thing that can be done if people just leave when they want to versus following the termination clause?
That's a really good question, and it has played out in legal matters. I don't know if they fought in the courts, but I've received a lot of calls on them. And here's the problem, and I've received it from both stable and boarder. Boarder does just that, just ups and leaves, takes their horses out, but the contract says that you need to give 30 days notice to the stable if you're a boarder before you go. And now the horses are gone. The stable may have a wait list, but they can't pull from that wait list. It's not enough time to get a horse in the barn. So the stall is left vacant. The boarding stable, if it's a busy one, relying on income from that stall, stable can't derive any income. The boarder walks out and then calls me and says, I left this stable because I thought that the care the horse was receiving was substandard and I wanted to protect the welfare of my horse. Stable calls and says, I have this empty stall and I have a boarder who left without giving notice and I want to sue them because now without that notice, I've lost the $450 a month that I would derive in board. So let's break it down. What do? Boarding stable. If you have a boarding contract that says notice is 30 days on part of the stable if the contract is terminating, 30 days on part of the boarder to the stable if it's terminating. The stable has the right to terminate if there is an emergency like we talked about. The stable may have a claim against that boarder if the boarder walked out and there was no problem with the quality of the service. So the stable would be able probably to go to a small claims court if they're permitted to do so and ask for collection of the $450. Some stables would say, hey, Fershtman, what about this attorney fee clause? We have a fee clause in our contract. Why don't I hire you and you go fight them out and run up a bill of a few thousand, and now they owe $450 plus a fee of several thousand. Yeah, sure, better that the stable does it on its own. So from the standpoint of the stable, having a clear termination clause is a really important thing. And of course, a clause with an attorney fee provision. That may make the boarder think twice before skipping on that board. Sometimes when the boarder calls and says, I want to get out of there. The care is really good, but I cannot stand this one boarder or this trainer or whoever. What do I do? To avoid legal disputes, to avoid the cost of a lawyer, sometimes the most reasonable thing for the boarder to do is to get their horse out, pay for that month of board. Yes, it might be a distasteful amount of money to pay, paying an extra month of board to the stable and then paying board at the new stable, but you have given yourself a better facility in your mind. You have avoided a legal dispute because now the stable has been paid. You've kept lawyers away. You've kept yourself from having to hire a lawyer. That's often the easiest thing to do. Finally, what if the boarder says, I've got to leave this place and I've got to leave now. I don't want to give 30 days notice. This stable is dangerous. Their pastures have exposed nails. It's just not a safe facility. They put my horse out with horses that are savaging it in the pasture. They're not feeding it right. Here's my response to that. If you believe, boarder, that the stable has fallen significantly short of its obligations and has threatened the welfare of your horse, and you can prove it, you can take pictures, videos, all kinds of things, you may be justified in walking out. Lawyers would call that the stable being in material breach of the contract. And the law tends to be, generally, that if there is a material breach by the stable, you're excused. You don't have to pay the board for that month. That is to say, the future board going forward, maybe the past board, depending on it, and you may be justified in walking out despite that 30 days. If you're in that position and you think the stable has done a terrible job and your horse is worse off for it, collect evidence, because if you have to fight it in court, that evidence will speak volumes. It'll make a big, big difference. And if the horse is ill, attributable to the care at the stable, and a veterinarian will prove it, that's great too, because you may have a claim against the stable if they've done something wrong to cause your horse to be hurt. Maybe they have feed that is tainted, they knew it, but they took their chances. They have hay that has all kinds of problems, they knew it, they took their chances. If your horse is injured from it, you may have a claim against the stable. Stables, what if that happens to you? You had a release of liability in your boarding contract. That's true, but sometimes a release doesn't cover everything. Sure, a release can protect you if it's enforceable against negligence, but serious wrongdoing on part of that stable, your release may not be enforceable. The point that I'd like to leave on this before we move on is collect evidence, keep proof of it by way of pictures and videos, and remember, if you're a boarder with a serious problem, you may very well be justified in leaving early.
Great, thank you so much, Julie. Lots there to digest for sure, but it certainly comes back again and time and again to having a good contract. So on that, we have two questions that I think are relatively straightforward to answer. Of course, nothing is really that straightforward. So the first one has to do with the termination, but in this case, is there a limit to how quickly a owner-operator can tell someone they have to remove their problem horse or boarder within? Can they say 24 hours? Can they say 48 hours? Or does it fall within that month-to-month contract?
I think the answer depends on the terms of the contract. I draft a lot of contracts for stables, and I have had a few that have said that in the event of an emergency, dangerous or destructive propensities of the horse or the owner, that the stable will give 24 hours. And I remember talking to a few of my clients on that, asking, are you serious? Do you really think a boarder in today's world, who probably doesn't have a horse trailer, although some do, is going to get out in 24 hours? And they just don't plain care. So if you want to be hard-lined like that, to protect your staff, your stable, everything, put it in your contract. Now, if the question is, what do I think about a very, very short termination obligation or termination option? I think it's heavy-handed in today's world, but if it's private property and the boarding stable stands by it and wants these people out quickly with an emergency or a difficult situation, they can do it. And if you're the boarder and you see something like that, and you do know that you have a horse that tends to be very difficult, you're probably not going to want to do business with that stable. They put it up front, go somewhere else.
Great, thank you, Julie. And then the last one is one to maybe end on because it's a little different here. In this case, the individual has a trainer renting half of their barn to someone else. And the question is, do they also need releases from that trainer's clients, or does is the release with the trainer enough?
Well, at the very core of it, let's talk about this. The stable owner has a trainer, and the trainer is utilizing a portion of the barn, but it looks to me like the trainer is now subleasing. The trainer was leasing part of the barn, maybe still is, but the trainer is subleasing a few of the stalls or some portion of the barn. At the very core of it, if you are the stable and you know who your trainer is, it's somebody with integrity, you want to deal with this person, they live up to their promises, you may not want that lessee, that subcontracted party on your property, because you may not have had a chance to vet them. So I want to get to the fundamental issue, which is in a contract between the stable and the trainer, for the trainer's use of that facility, wouldn't be a bad idea to have a restriction against subleasing unless the stable approves it. That way you've got some degree of control over who is in your barn. But let's get down to the question of releases. If a person is injured on the property of the stable, and if the trainer is completely responsible for that relationship, let's break it down. The trainer has a boarder who is in training, the horse is in training, that is, and the stable does nothing more than provide the facilities, but the boarder, or the trainer rather, has a student who falls, gets injured, something happens. It's a reality in today's world, for better or worse, that injured person is going to sue the trainer, and they're going to sue the stable. It's just the reality because lawyers tend to cover everything. So what does the stable do? A couple of things here. The stable would be wise to make sure that everybody who enters the property signs the stable's release of liability. And in my opinion, the trainer's release could have a clause that says, I, the signer, agree that I will not sue the trainer and I will not sue the stable. But I think taking it one more step with the stable having its own separate standalone release is a good thing. Why? Well, it's more paperwork, and everybody hates paperwork, I know that. Or if it's online, it's yet another nuisance to some. But the fact of the matter is, the stable is simply offering property. The stable, I'm assuming, is not a partner, not a business partner with the trainer. It is not a joint venture. They're not in business together. The stable is simply giving property to the trainer to do its job. The message you're sending to people by having your own separate release as a stable is that you are separate. And that will be helpful because when that lawsuit comes in from the person who was injured, that's the trainer's customer, and they go after the stable, your argument might be, we are absolutely separate. All we did was offer the property. So sorry you fell down riding your own horse in a lesson in my indoor arena. But my arena had nothing to do with your fall, other than you landed on the dirt that I own. If the stable has its own separate release, you are sending the message that you're separate, you're independent. And I think that plays importantly in your defenses. Breaking it down then, the stable who is leasing its stable to a trainer, which has a subtenant, no matter who is leasing the property as tenant or subtenant, have them include the stable in their release of liability as being released. But I do recommend that the trainer require everybody of legal age sign the stable's release as a separate document for the obvious reason. And that the trainer and the sub-trainer give those documents back to the stable every week so that the stable has them on file if they're on paper. That to me is absolutely critical to protect the stable. And of course, the stable will have liability insurance. The trainer will have it. Maybe the trainer will name the stable as an additional insured. These are requirements too. And the sub-trainer, he or she, I would imagine, would have liability insurance protecting themselves, perhaps protecting the other trainer who brought in the sub-trainer, and protecting the stable. Sounds complicated, it really isn't when you break it down. And any knowledgeable equine insurance agent can help you do that too. So it's a lot of things to cover. It's a lot of paperwork, but because I deal with lawsuits involving equines, these are things that I think are very important. Releases from everybody and carefully drafted paperwork.
Great. Thank you so much, Julie. We do have a few questions that came in a bit ago that we were not able to get to, and I know we are past the 7 o'clock mark. If you are able to stay a little longer and try to tackle those, that would be wonderful. If not, we can.
Sure.
Okay, super, great. So much appreciate that. And for folks that have been on, if you can continue to stay, that's great. And if you can't, we will continue recording as well. So the first one is there a personal liability insurance option for staff who work at a boarding stable?
Personal liability insurance option for staff who work at a boarding stable? That's a loaded question.
Yeah.
And the reason is this: people who work at a boarding stable are working for somebody. If you are talking, for example, about boarding stables where your customers are cutting down on their board fee by cleaning stalls, pasturing horses, putting shavings in the stalls, sweeping the barns, you get the idea. It's a very complicated area that you're getting yourself into, because this person may be viewed by you as a mere contractor, but in the eyes of the law, California, for example, might say you're an employee. And because of these difficult questions, the safest bet for a stable, except the most expensive option, is to purchase some form of workers' compensation insurance. And anybody who is doing anything on behalf of the stable, whether you are paying them for their time or giving them a break on their board, has that insurance as recourse if they're hurt in connection with an activity at the stable. That's the safest bet. Stables don't like it though. Workers' comp insurance isn't cheap, but it is the safest bet. And here's why it's important. If you say, stable owners, you know, I don't want to buy the workers' comp, but I do have that commercial liability insurance that Fershtman was talking about. Well, that's great, except that your commercial liability insurance policy has an exclusion for employees, and sometimes these employee exclusions get broadened out to people who are working or performing services for the facility. Now you've got a problem, because when that injured person gets kicked in the head or sustains a major injury, your business liability insurance policy may completely walk away based on that exclusion. You've got a significant problem. So what are your options? Having workers' comp insurance, expensive but safe. Having commercial liability insurance, risky, probably not going to cover these situations. Can you have a release signed by people who are doing services for you? It depends. Some states would say if a person is working on your behalf, especially if they're an employee, you can't have them sign a release. Other states aren't so clear, so it doesn't matter. So with all of that in mind, it is a very sticky situation when you are dealing with people working on your behalf. And the sad reality, in my experience, most stables don't have any insurance whatsoever to protect themselves from injured workers on the property. So that's about the best I can offer. One final, I suppose, option is, in the era of Obamacare, which is still here, require anybody who is on the premises doing anything for you, show proof that they have their own health insurance. That's an important thing to consider. But frankly, my experience is a lot of people just plain don't purchase it. They're supposed to, but they don't. Now you've got a problem. And then adding even more, some insurance companies will pay those medical bills for that worker who got kicked in the head, and then they'll turn to you. They'll bring a lawsuit potentially against you. Lawyers call that subrogation. And now that insurance company who learned about the worker getting injured by a kick in the head at your farm is coming after you as on assignment from your injured worker, saying, well, we just spent $150,000 on legal fees, pay us back. This gets pretty sticky. So I'm glad the question came in. It is a lot to think about. And I hope everybody here will keep all of this in mind, because injured workers happen and it'll continue to be a problem.
Great. Thank you, Julie. So we have sort of two questions that we can combine here. What if a boarder leaves their horse behind and you're not able to find them? What is the time you need to keep that horse? And I think associated is if you end up end up having a lien and the lien is not satisfied and a horse is to be sold at public sale, does a professional auctioneer need to conduct the sale, or can the stable owner accept bids? I'm thinking that maybe that's a combined scenario to address.
It is, and I'll address it together. I talk about this in my Equine Law and Horse Sense book. This is a scenario that plays out more frequently than we would like, and I'll bet it's going to happen more because COVID is affecting people's bottom line. A stable is left with a horse where the boarder can't be reached. The horse has not been attended to. Maybe the boarder hasn't even had the vet or farrier out, and the stable, of course, hasn't been paid. So what are the issues here? What happens when this occurs. Let me try and break it down. Often stables make their own conclusion, which is a very important legal conclusion, and it's ill-founded. And they'll say, well, the owner hasn't been out in a few months, so the horse is abandoned. And now I can put this horse in my lesson program, or now I can sell the horse. There's this person down the aisle who really likes it, and I'm just going to give them a bill of sale. And stables take it upon themselves to make a lot of big decisions. Big mistake. So when a horse is left in a barn and the owner can't be reached, I want everybody on this webinar to know that abandonment is a legal conclusion that can only be made, in my experience, by a court of law. You can't make that decision on your own. Courts will look for evidence of the animal being left with absolutely no intention on part of the owner to reclaim the animal. There is a passage of time that different states are looking for. And unfortunately for abandonment, it tends to be that a judge needs to make the decision, not you. So be aware that before you conclude, we've got an abandoned horse, it's complicated. Now let's get to the next question about stableman's lien laws. And I did talk about that briefly in my presentation. Every state, to my knowledge, has some form of a law that gives stables certain rights with regard to boarded horses. That's nice. The bad news, they all differ. And I talk about that in a section of my book where I give examples. In my state, I'm in Michigan, a stable has an automatic lien. So the minute that horse is brought to the stable, the law creates a lien, and you can't see it, you can't hold it. It's not a piece of paper, but it's there. And that law in my state, Michigan, says that the stable can insist on keeping that horse until it's paid in full. And then it goes on in my state that says 9 months must pass without payment, and then the stable can sell the horse. But the law is very clear that the stable has to hire a sheriff's deputy or court officer at or after the 9th month to do the sale. So the law is telling you what to do. But then you get other states that say for the lien, the stable has to go to court, and the court has to issue the lien. That means the stable has to spend a lot of money on legal fees, dealing with judges who don't know what the law is here, a lot of work on part of a lawyer, but you have to go to court to get that lien. Then you get some states that say that you have to go to court to get a foreclosure order before you can sell the horse. That's an expensive option. So in a long-winded way, I think you get the point. Every state is different with regard to what the stable's rights are when the boarder leaves the horse and doesn't pay. Please make sure, everybody, please make sure that before you do anything drastic, like take the horse to an auction, hire someone to sell it, please make sure you follow the law of your state, and please don't listen to somebody online, through a chat forum, anywhere, who is not in your state, because they're looking at a whole different set of obligations than you. So the takeaway, follow the law in your state, follow it to the letter, and here's why. The person who buys the horse at your illegal sale because you didn't follow the law correctly, they now have a problem with you because you didn't have legal title conveyed. You didn't own the animal. By virtue of following these lien laws in the various states, you can acquire title, the ability then to resell the horse, and the owner is solid. They've got ownership, and the registration will transfer from just about every registry if the law is followed. But it gets worse. The owner of the horse, when you botched your lienless sale, may have a case against you for theft or conversion. You took their property and you didn't dispose of it properly. That's a problem. And the police may be going after you too for theft or conversion because you didn't follow the law. You took someone's personal property and you disposed of it wrongly. You can get yourself into a lot of trouble. Again, please follow the law of your state, and please follow it very carefully.
Thank you, Julie. And again, I think you're right. Given the financial scenarios we are in, that is definitely something for us to be thinking more and more about. So we have two final questions here that I think, again, we can kind of address together. One has to do with any recommendations that you have for certifications for instructors coming onto their property. That's sort of a, do you have any suggestions? And the second is, how do you handle a boarder that allows people that are not experienced enough to ride their horse go ahead and do that? So how might you address that? I guess it could also be an instructor who's coming in and is allowing people to ride horses that they don't feel is appropriate.
Let's break it down. Let's get to the first question, or the second question first. You are a boarding stable and you've got an owner, or rather a boarder at your stable who is doing things with their horse that you don't quite get. They're bringing coworkers, or if it's a student in college, they're bringing their friends who don't know how to ride, and your boarder is having them engage in unsafe practices. It's a tough call right now for the boarding stable, and here's why. All you do, boarding stable, is provide a stable for people to do what they want with their horses within your rules. If they're engaging in unsafe practices and you start nosing in and telling these people what to do, I'm concerned about you from a legal standpoint. Why? Because the minute you undertake to involve yourself in promoting safety with your boarders, to literally step in the arena and tell the boarder, get this person off the horse, the stirrups are too long, this is the wrong kind of saddle, your bit isn't properly adjusted, or any number of things, you've set yourself up for the next time when this boarder does something wrong and perhaps you saw it and didn't engage yourself. Will somebody who is injured look to you, stable, as potentially being liable for not stepping in? I don't think it's reasonable, but trust me, lawyers sue for everything. So the difficult position that you are in as a boarding stable is it's really not your job to supervise what they're doing. What is within your rights and the safest option, in my opinion, maybe offer a suggestion, but don't involve yourself too extensively. Give this boarder a 30-day notice to get out because you think that they are simply engaging in unsafe practices and you don't think that this is likely to turn itself around. So the point I make is, unless this is your training customer who's bringing friends to play around with the horse that you are training and messing up the horse that you're training, that I think calls for you to step in. A boarding stable is in a very tenuous legal position with regard to what the boarder is doing. I make an exception on that for the helmets. I think it's a good idea, as I've mentioned, for a boarding stable to have a release that mentions that boarders are aware that they should purchase properly fitted and secured ASTM standard SCI certified protective equestrian headgear. Getting more detailed than that, I think, is getting the stable in a tough position. Let the boarders do what they want, set your rules, but don't nose in too much for fear that you're setting yourself up. Let's get to the question now about a boarding stable where you have a instructor who wants to come in and give lessons. The question, I think, was recommendations. I'm going to view this question as a question for what the stables can do to get some degree of control and, frankly, to protect themselves in the situation of the roving instructor. And I believe that's a section in my book as well. A couple of things. Number one is that I think the boarding contract should have a clause that independent instructors and trainers are only permitted on the property with the stable's advance written permission. And you can put that in your releases too, so that the world knows that you are in control of who's giving lessons and who's training. That sets the ground rules there. But let's go even further. Once that trainer or instructor comes to you, boarding stable, and asks, may I do business on your property? I'd like to board, I'd like to train or give lessons. Here's your chance to have another contract with this independent trainer. Yeah, I know people listening are saying, here goes the lawyer talking about another contract, but this is really important. Let's talk about some of the things that I would want in your agreement, boarding stable, with this roving trainer or riding instructor. Number one, I want it in writing that they agree that they will use a liability release that you've taken a look at and you've approved. You're not a lawyer, you can show it to the lawyer. And that way they have their release, you have yours. You've already heard me comment on why I think it's important to show the world that you're two different things, different entities, different operators. Number two, you want it in writing that that independent trainer or instructor has liability insurance, business liability insurance applicable to lessons, and you, stable, have told them, I want minimum policy limits of blank, maybe 500,000 per person, 1 million per occurrence, and you want them to show you a copy of their declarations page that proves that they have the insurance, and you want them, you can put it in writing, to show you that they are naming you as an additional insured. It gets tricky on additional insureds, talk about that with your lawyer, and you want them to have a written indemnification agreement that if somebody gets hurt and you are blamed and you are sued and you have nothing to do with it, that the trainer instructor will make sure you're protected. but that's where the liability insurance backs it up. And you want it in writing that you have the ability, stables, to call this deal off at your discretion or to set reasonable limits on what these people can do. If it isn't in writing, it gets very, very difficult to deal with independent trainers and instructors. Let's take one moment here and shift gears. You're the roving instructor. You're brand new. You've just gotten certification from CHA or ARICP or another entity. You don't have a lot of money to purchase liability insurance, but you really want to start and get some cash flow so you can buy insurance. What do you do when the stable is imposing all these requirements? Well, I guess what you do is you can't work at that stable. But these requirements are designed to protect both of you. So it's a difficult position, but I strongly recommend if you are a trainer or instructor that you be ready for these kinds of contracts and seriously consider purchasing insurance. You can break it down and get installment payments. You can work it out with an insurer. If you're new and have a small operation, it might translate into a smaller premium. I want to make clear to everybody listening, a lot of my clients in the horse industry are insurance companies, but I don't sell it. I don't make money when people buy the insurance. I think it's just very good protection. Any more questions?
Julie, that we have managed to cover all those questions. So thank you so much for extending your time with us. The information so incredibly valuable. It's always important for us to be thinking about these contracts, but I think across the spectrum today we're really in a need to go back and have an opportunity here to really go back and look at our contracts with fresh eyes. And while we can't anticipate the unanticipatable, we certainly can learn from those things and can really continue to refine to make sure that we have good contracts. And I am so glad that you put up the reminder about your new book, your Equine Law and Horse Sense book, which I know has just, again, a wealth of experience and background through all of those pages. And we thank you so much for your time with us here tonight, Julie. It was truly a pleasure.
Thank you for having me. It's been fun.
Great. Thank you, everyone. We will be moving this over and posting this as a web recording. And please also anticipate you'll receive a bit of a follow-up evaluation, a feedback form. And we thank all those folks that have been on with us tonight. Thank you again, Julie. And Jenny, thank you so much for being our fantastic IT person behind the scenes to make sure this all worked. Good night, all.
Karen, thank you for everything.